Further hearing in the appeal of the Grandview Private Trust Company and another against Wang and others.
Mr. Howard. My lords and my lady, having reflected on where we've got to over the last 2 days, it seems to us there are two legal arguments which underpin the appellant's approach to the construction of the trust deed. And both legal arguments are of some importance in relation to trusts, and particularly offshore trusts, and your Lordship's and Ladyship's decision about them will have very significant practical implications. So I want to begin by addressing those legal arguments which we say are misconceived. I will then come back to saying something more about the proper construction of the trust deed before I move on to issue 2. Now, so the legal arguments that I'm going to address, the first argument is what was called the so-called contracting out of equity point, as my learned friend Mr. Wilson put it. And the second argument is that a trust that is expressly stated to be for anyone except X would be invalid, and so you shouldn't construe the GRT in a way that would make it such a trust, since, as I understand the submission, that cannot be what the settlor intended. So turning to the contracting out point, in an exchange with Lord Hodge, Mr. Wilson said, there is no need for a settlor to say that a power of addition may be exercised only in the interests of existing beneficiaries, because he says that's naturally the position effectively, and parties need to opt out of the rule of equity that says that if they don't want them, not opt in if they do. Now, the suggested point of principle, which is sought to be invoked, is that duties of trustees must be owed to the existing beneficiaries or objects. Now, in our submission, that is a serious oversimplification in cases where trustees have power to select and deselect beneficiaries from a wide class, including a class of anyone in the world except X, still more so where you have a power of addition. In that situation, the duties of a trustee, we say, have been established to be to consider the range of his powers. Now, you've seen cases already, such as Manesty. Can I, because I'm short of time, just give you the reference and you'll look at it. Hayes Settlement, a well-known case. It's in the bundle at 4923, and you'll remember in that case the trust was to run for only 21 years with default beneficiaries who were the settlor's nieces and nephews, and an intermediate power of appointment in the meantime for anyone except X, i.e. the trustee. And you can see that at 4925H. Now, if Tony's submissions are correct, the power in that case, in Hayes Settlement, could only be exercised in the interests of the nieces and nephews, because the nieces and nephews, who were the default beneficiaries, were the only named beneficiaries in that case. Now, the Vice-Chancellor, Mr. Justice McGarry, he did not think that the power was limited in that way. What he said was that there was an enormous class of possible objects and you needed to survey the range. Now, the discussion, your Lordship should read pages 4928 to 4931, but this discussion in that case would have been entirely otiose if the position was, as a matter of equity, that the power had to be exercised in the interests of the niece and nephew. How could there be this enormous class if actually all you were going to do was to exercise the power in their favour? Now, what that case shows is, and this is what is said in it, you have to consider the range of your powers to select and deselect before exercising them. And it's not right to say you are to act in the interests of the beneficiaries. What the true principle in equity is a far simpler one. The power that is granted must be exercised for the purpose for which it was created. And there is no principle that a power must always, or by default, be exercised in the interests of the existing beneficiaries. The question is always going to be, what was the purpose for which it was created? And we've already looked at cases like Schmidt, Manistee, Beattie, now Hayes, and in our submission, they all illustrate that. And so the submission that Mr. Wilson made to you, for example, by reference to Cowan and Scargill and Sir Christopher Nugent's advice, is misconceived because it misstates the rule of equity, which is, as I say, a power, whatever the power, must be exercised for the purpose for which it was created. That's the first point I wanted to make today. The second point is this. We are concerned not with just any old power, we are concerned with a power of addition. Now, cases in our submission, such as Barden, which I'm going to come on to, Manistee, Beattie, Schmidt, well-known examples, English law has accepted that it is open to settlors to give the trustee the power, a power to add to the class of beneficiaries, even where that would not be in the interests of the existing beneficiaries. And in our submission, to create a default rule now that a power to add may be exercised only in the interests of existing beneficiaries, and that a settlor must contract out of this by express words, would, with respect, be tantamount to legislation, because no authority has ever recognized such a principle in the context of a power of addition. Now, even if this court considers that such a principle is desirable in principle, we submit it could only be introduced by legislation because countless trusts involving millions, indeed probably billions of pounds, have been set up on the basis of the views expressed in a stream of case law since, for instance, Manistee. And in our submission, this cannot be overturned by judicial decision, which is necessarily retrospective. And of course, the 1966 practice statement acknowledges that a decision should not be disturbed if it would upset settled transactions. And if you pause to ask yourself for a moment, what would be the practical consequence of adopting the appellant's default rule? The answer is that it would drive a coach and horses through all of those trusts that have been set up in the light of the Manistee line of authority. For example, if the settlor names a charity as default beneficiary while giving trustees a power to add to the class of objects, a trust structure that is common in practice, the effect of Tony's case is that the settlor is, quotes, taken to intend, quotes, to benefit the charity, even though that is obviously not what he intends. In a case like SOFA, the effect of Tony's case is that the trust would fall to be administered for the benefit of Freshfields and CMS, even though, again, that was manifestly not what was intended. In a case where the trust names certain individuals as beneficiaries or objects, the settlor may not have any absolute or unqualified intention to benefit them. But the effect of Tony's case is that such an intention is nevertheless to be imputed. Now, all because, it is said, the settlor has not expressly contracted out of a supposed default rule. In other words, as we understand it, he has not expressly said, oh, by the way, the power to add that I'm giving you may be exercised for the benefit of someone other than the existing beneficiaries. Now, in our submission, this would have the effect of defeating what the settlor intended and render discretionary trusts that have been established unworkable. So that's dealing with that first legal argument.
Can I just be absolutely clear in terms of authority? Has this precise argument ever been discussed as such in any past authority? I can see that you've given us cases where you might say that the reasoning may be regarded as inconsistent with it, but then, as far as I understand it, no case, as far as I can see, but this is what I'm asking you, has specifically addressed this point.
If one, I'm grateful for that question, my lord. If one says, is there a case where this is specifically discussed in these terms, I agree, no. Are there numerous cases where everybody has proceeded on the basis that that can't be so? There are literally numerous, and cases of the very highest authority.
Yeah.
And one would have to assume, frankly, and I say this, and the court needs to confront this, it's to say, well, Manisty, Hayes, Schmidt, this very argument wasn't made. But you then have to say, well, really, everybody's proceeding per incuriam, and that eminent chancery judges, steeped in, I mean, I point to this not because, I mean, obviously, Lord Hoffman, Lord Templeman were extremely eminent judges, but these are also people steeped in chancery practice as practitioners and so on. One has to say that they all have overlooked this, what Mr. Wilson says, well, this is just a basic point of trust law.
And can I then just follow that by, are there any academic analysis of this precise point, rather than phrases about in the best interests of the trust, but not necessarily in the precise context of addition of...
There are the articles by Nolan and Hayton, which I've referred you to. Yes, I'll give you the reference in a moment.
Thank you.
If I can.
They discussed this precise point
Yes.
of additions, whether controlled by a best interests of the beneficiaries. Yes. Thank you.
I mean, you found on cases like Schmidt and Manisty, but Nin, for example, is a case where the interests of the legitimate children were, in a sense, compromised by the addition of the illegitimate children. The cake was shared out more widely, and if it was a point to be taken against the part, one would have expected it to be taken in that case.
That's true in all these cases, and I would respectfully say, I appreciate where this is at the highest level, and obviously I'm used to appearing as an advocate at this level, as you know, but at the end of the day, the court can, I mean, one can, as it were, say, I'm discarding these cases on the basis, well, the exact point wasn't decided. But as I say, I would respectfully suggest one ought to tread extremely carefully when it is clear in all these cases that no one was making us these suggestions, which would have been the obvious suggestion if there were this default rule of law. That's one point. And the second point is that the trust industry, which concerns literally, as I say, billions, have been working on the basis of this approach.
Yes.
So that is this sort of a point which I think the court seemed to be seduced by. Well, you can't contract out, and there's a default position.
Well, you have to find the default position before you need to contract out,
exactly.
and your position is that there is no such default position.
Precisely so.
Yes, I have the point, thank you.
Now, the second point I want to go to, which is a point that...
Sorry, just if people did want the page references to Hayton and Nolan.
I'm sorry.
I just made a note of 2707 is Hayton, 2913 is Nolan.
I'm very grateful to my lord. And I apologise if I'm appearing to go too quickly. It's just I'm obviously short of time, but I'm not seeking to stop anyone who wants to ask questions. I'm here to answer your questions. So please.
Clearly, but no, I see you asked us to look at those cases, and I think I and my colleagues have read them overnight.
I'm grateful.
And so I see the point you're making.
The second point, which is also a sort of fundamental point which is being made, is whether there is some legal rule that prevents settlors setting up a trust for such persons as the trustee selects from time to time. Now, the reason, of course, this is relevant is on our construction and the Court of Appeal's construction, the effect is that you do have a roving class of beneficiaries. I don't shrink from that, nor did the Court of Appeal. And, well, what is said is, well, that can't be right, that you could have that. Now, it is important for your lordships to look closely at the Barden number 1 case, which is at 4793 of the authorities, Now, again, I'm not going to, it's not going to be a good use of time to read out passages, and I'm sure that's tedious for your lordships anyway. What I'll do is just highlight the passages which I would suggest merit consideration.
If you could give us the principle you're taking from them and then list the passages that support the principle.
In order to explain the principle, the issue that was being debated in Barden was whether there was a different certainty test for powers as opposed to for trusts.
Oh, yes.
And when the case came to the House of Lords, there was a difference, or at least there was a perceived difference, based on a case from 1955 in the Court of Appeal called Broadway Cottage. And that had established that there was a stricter test for certainty for trusts. So what that meant was, it was said that for a trust, it was necessary for the trustee to be able to draw up a complete list of beneficiaries. And that was the question, whether that was right. And in Barden, the House held that the distinction was unprincipled. It decided that the conceptual certainty test was applicable to trusts and powers alike. So a trust is sufficiently certain if the trustees are able to say in relation to any given individual whether that person is an object or beneficiary or not. And that's and so we say that Barden, properly read, does say you can have a trust which is for the benefit of everyone except X. And it's important to note, because we're going to come to an article by Professor Smith, who is in court today, so welcome, Professor Smith, no doubt you know him, but in which Professor Smith, and you've been referred to it a number of times by my learned friends, it's important to note, Professor Smith, and he's entitled as an academic to say this, he says the majority in Barden are wrong. He prefers the view of the minority. He also says Schmidt is wrong. Now, that's fine. He's entitled to say that as an academic. But no one is inviting this court to depart from Barden and Schmidt. And you're, of course, familiar with the practice direction as to what is to be done if you are being invited to do that. So I am entitled to proceed, and I do proceed, on the basis that Barden represents English law, and Schmidt also represents there. Of course, it was the law of, I think, the Isle of Man, but effectively is also representing English law. Now, and for your note, in the article, Professor Smith refers to Barden number 1 by the name MacPhail and Dalton, but it's the same case. I'm sure
Mrs. Talbot Rice indicated that there was a problem with these trusts, not in terms of certainty of objects, but in terms of administrative unworkability. Is that part of your
I'll answer
thinking?
the point about administrative unworkability and explain why that is nothing to do, that there's not a problem at all, and it's a misunderstanding of the Barden case. The relevant parts of Barden in particular, but as I say, it's important to note that Lord Wilberforce was in the majority, and the relevant parts of his speech that I would refer you to are at really from 4817 at the foot of the page at G to H is where his lordship makes some general observations about the distinction between powers and trusts, and basically saying this is nonsensical, perhaps in a more polite way than I would. And you can pick it up again at 4819 at G, where he explains that they're being asked to assimilate the validity test. Alternatively, it was the Broadway Cottage test was too rigid, which he agreed, but it didn't dispense with the point. And if you then go to 4820, at E to G, he is discussing the Richardson and Chapman case, and what he concludes at G is that this shows that the court can, in a suitable case, execute a discretionary trust according to the perceived intention of the trustor, i.e. the settlor. It's interesting also to see, it doesn't seem to be, that's the particular case. So the court can execute a discretionary trust according to the perceived intention. And then at 4822 at D to E, well, you need to pick it up.
Looking at E to...
I'm sorry, my lady, I didn't catch you.
4820, that class, my worthy friends and acquaintance, particularly the Reverend Dr. Richardson, was that sufficiently certain, or...
Yes.
Right.
And at 4821, at the foot of the page, at H, he's explaining how the law, the modern shape of the rule came from Res Gestetner, where a judgment of Mr. Justice Harman, who to his later regret established the distinction between powers and discretionary trust. And if you go over the page, he refers to, at C to E, he cites with approval the passage that Mr. Justice Harman was quoting from, or a passage from Mr. Justice Harman's judgment, I apologize, where it was said that you could have a very wide class of beneficiaries. You see that he, at C to E, so the settler has very good reason, I've no doubt, to trust the persons whom he appointed trustees. Cannot see here that there's such a duty as makes it essential for those trustees to survey the whole world and to consider whether A is more deserving of bounty of B. That's a task which must have been known to the settler to be impossible. And then after, in the next paragraph, he talks about how you go about ascertaining who you're going to give the bounty. In other words, the mere fact that it's anyone in the world from but X doesn't mean this was about a power that you literally have to consider everybody in the world. And the important point is then at 4822 at G, he says that, or at F, he says, subject to one point which was cleared up in the House of Lords, I may say so, if I may say so, this seems impeccably good sense. If the judgment was in any way the cause of future difficulties, it was in the indication given, not by way of decision, that there was a distinction between the kind of certainty required for powers and that required for trust. There is a difference, perhaps, but the difference is a narrow one, and if one is looking to reality, one could hardly find better words than those I've just quoted to describe what trustees in either case ought to know. A second look at this case, while fully justifying the decision, suggests to me it does not discourage the application of a similar test for the validity of trusts. And at 4825C, he expresses his conclusion, which is that you can see C, the sentence beginning, the conclusion I would reach is the wide distinction between the validity test for powers and that for trust powers is unfortunate and wrong, and the rule in Broadway Cottage ought to be discarded, and the test for validity of trust powers ought to be similar to that accepted by this House in Gulbenkian for powers, namely that the trust is valid if it can be said with certainty that any given individual is or is not a member of the class. And he also says at 4826 A to B that the court will, if called upon, execute a discretionary trust in the manner best calculated to give effect to the settlor's or testator's intention. Now, before I come to the point he makes about administrative workability, point my Lord Burroughs has raised, which is in the paragraphs that follow at the end of the judgment, two propositions come out of Barton. The first is a trust, just like a power, is sufficiently certain if in relation to any given person, the trustees are able to say whether that person is a beneficiary or not. Second, the trustees are obliged to execute the trust according to the intention of the set law, and if they fail to do so, the court will execute it in the manner best calculated to give effect to that intention. So the submission that Winston has made, and you'll see that at paragraph 63 of his case at 1774, that a trust for anyone in the world except X would fail for uncertainty of objects, is wrong, and obviously wrong in the light of Barden. If you have a trust for anyone except X, X being the trustee, that satisfies the Barden test of certainty. And Mr. Justice Hoffman expressly said that in the Beattie case. I'll give you the reference at page 2368, letters D to E. And you'll remember Mrs. Beattie's trust provided the trustees could distribute the trust property to such person or persons as they think fit. Now, and in the particular case, the judge, that there was, in Barden, there was no problem. Now, Lord Wilberforce refers to a different problem at D to E, and or the bit that we're particularly concerned with, well, I think we need to pick up the whole thing. He says, I desire to emphasize the distinction...
Which page
sorry, I apologize. I'm going too quickly. 4826.
4826.
The end of the judgment in...
At the very end, yes.
Yeah. So, and this is the famous example that Lord Wilberforce gave of administrative unworkability. And one has got to remember, this is in 1970. So why this is administratively unworkable and why this is actually quite different to anybody in the world except X. So what he's talking about is, first he says at D, I want to desire to emphasize the distinction made and explained by Lord Upjohn between linguistic or semantic uncertainty, which if unresolved by the court renders the gift void, and the difficulty of ascertaining existence or whereabouts of members of the class, a matter with which the court can appropriately deal on an application for directions. There may be a third case, where the meaning of the words used is clear, but the definition of beneficiaries is so hopelessly wide as to not form anything like a class, so that the trust is administratively unworkable, or in Lord Eldon's words, one that cannot be executed. I hesitate to give examples, for they may prejudice future cases, but perhaps all the residents of Greater London will serve. I don't think a discretionary trust for relatives, even if a living person falls within that category. Now, it's important not to lose sight of what he's talking about. Lord Wilberforce wasn't saying that a trust for all residents of Greater London failed for uncertainty of objects. He wasn't saying that at all. What he was saying was it may be administratively unworkable. But the reason for that is all the residents, all is an important word here, of Greater London, is administratively unworkable in that it's probably impossible to identify every single resident of Greater London. You simply cannot do it. Now, Mr. Justice Templeman explained this in the Manisty case, and that's perhaps worth looking at.
Sorry, just before we leave it, is Lord Wilberforce looking then at if you like, a fixed trust that every person who's a resident of Greater London will get £1?
Or it could be a discretionary trust for all the residents. In the narrow sense, yeah, not not. I mean,
sorry, what do you mean by that?
Well,
because I mean, presumably you could say of someone who came forward and said, "I'm a resident of Greater London," yes, they are, or no, they're not. You depend on the evidence.
It's where there's an obligation towards all the residents of Greater London.
That's what I was driving at.
Yes, that's what he's talking
Well, that wouldn't necessarily include the discretionary trust, because if someone comes along with their council tax demand showing that they're a resident of Greater London, then the trustees will be able to say, well, you are within the class.
Yes, I mean, if it's just you can select within the class, but it's if you have an obligation to be able to identify every single person,
Right.
then...
Well, that does suggest that he's not talking here about a discretionary trust.
Well, it's two things, but even if he is talking about a discretionary trust, it's only unworkable, and it only becomes unworkable if you're under an obligation to consider everybody.
So there's one sort of discretionary trust, which in fact is the McPhail-Dalton sort, where it's extremely wide, but you're not under a fiduciary obligation to consider everyone before you exercise the power. And as I understand it, that's effectively what the issue.
It's really the administrative unworkability. I'm
just trying to get it clear in my mind.
Yes.
But there's another form of discretionary trust where before you exercise the power to appoint or whatever, you do have to have considered the whole range.
Well, it could be if that's how it's specified. That's right.
Right.
But
and so is it that sort of, insofar as Lord Wilberforce here is dealing with a problem of administrative unworkability, is it, and insofar as that applies to a discretionary trust, so I was putting to you a simple case, £1 for every resident of Greater London, you're saying, well, it might be a trust in a discretionary form, but as I'm now understanding what you're saying, you're still drawing a distinction between the actual trust in McPhail-Dalton, which did not import an obligation to survey the whole field, and a discretionary power which can only properly be exercised if you have surveyed the whole field.
Yes.
Is that the point of
I think
distinction?
the critical point, I think, is that he's talking about the class. If you look at what he says, it's so hopelessly wide as not to form anything like a class, so that you can't actually tell who it is you're supposed to be considering, because it's just simply can't really tell who is, that's what he seems to be suggesting, who is a member or who is a resident of Greater London. It's not entirely clear, but what...
I struggle to see how you can't tell who is a resident of Greater London, because,
today,
as I say...
You have to remember this, today, this is in 1970.
Yes.
So today, your lordship may be right, well, we all unfortunately have to pay council tax, so you'd be able to...
But we had to pay domestic rates.
It's the point that there are some people, and there were even in 1970, who were clearly living in Westminster and so were clearly resident, and there were some people living in York who are clearly not residents. So it's a class where it is possible to tell with some people whether they are in or out, but there's a grey area.
Yes, but the difficulty is
the question is
what he's talking...
Well, that's I think the point that my Lord Sales is...
No, but that's what I'm saying.
Yes.
You have to look at what Lord Wilberforce said here, and what he's saying is, well, there may be a third category where the definition of beneficiaries is so hopelessly wide that it's not a class, so that the trust is administratively unworkable. Now, that will actually, if you had a trust, I mean, if you take Lord Wilberforce's example, if the trust is, you have a power to make distributions to anyone who is a resident of Greater London, there's nothing administratively unworkable about that, because you don't have to survey the whole class, as long as you are considering people...
Right. That's what I'm just trying to understand what you're saying, Lord Wilberforce is saying, where the point of distinction is, because McPhail-Dalton, it is a very wide class, but if any one person came forward, or the trustees fastened upon any one person, you could say of that person they're within the class, and that was good enough in terms of certainty.
Yes.
So Lord Wilberforce is obviously contrasting that sort of situation with something else, and I'm just trying to get a handle on what the something else is.
Yes.
Yes, I mean, I've got the same problem, if I may say so, because as I understood it, this discussion was having moved on from conceptual certainty, there is another problem. Now you've been explaining this to us in terms of conceptual uncertainty, that we don't know actually who's a resident or not. But as I understood it, that class is conceptually certain. We're now talking about a separate problem of administrative unworkability, and the difficulty is pinpointing exactly what that means.
Yes.
And I think your answer is, well, whatever it means, if you're able to establish that someone is within a class, if the trust is so worded that you can establish that someone is within a class and you don't need to know the whole class,
yes.
Then there is no unworkability.
My point is a simple one, exactly as Lord Hodge says. The question where this all arises is, if this is a trust for anyone in the world except X, is that okay? Now, or a trust, whether this is that trust. My answer is, Barden says it's okay, and one also sees that in cases such as Manistee, Beattie, and so on. And
well, I know that's what you're saying.
Yeah, I mean,
but the point is, it's okay on conceptual certainty. There's an issue, I think, put against you that it nevertheless fails for administrative unworkability.
And what I'm saying is, no, it doesn't, because there is, if you don't have to survey the whole class, so that if, and that's what the McPhail and Dalton is saying. That's what, and one sees that also in Hayes as well. So as long as you know who it is you're supposed to be, well, sorry, let me start again. You don't have to be able to survey the whole class. So as long as the class is one that you can identify, as I see it, what Lord Wilberforce was saying, if you say all the residents in Greater London, that has a vagueness about it, which means that you may not be, and he only says perhaps, you may not be able to be certain who it is intended to be within the class. And can I show you what Lord Templeman said about it? That may, or Mr. Justice Templeman, as he then was, at 2406 in the bundle. At letter C, having quoted from Barton and that passage, he says, in these guarded terms, Lord Wilberforce appears to refer to trusts which may have to be executed and administered by the court, not to powers where the court has a more limited function. Moreover, a capricious power exercisable in favour of residents of Greater London may, as I've already outlined, well be uncertain. The settlor neither gives the trustees an unlimited power which they can exercise sensibly, nor a power limited to what may be described as a sensible class, but a power limited to a class, membership of which is accidental and irrelevant to any settled purpose or method of limiting or selecting beneficiaries. So essentially, in our submission, he's saying, well, it's unclear exactly what Lord Wilberforce meant, but he interprets it as, well, if what you do is define matters or in a way that is capricious, so that the trustees or the court couldn't know who be certain what you actually intended to convey as to be the beneficiaries of your bounty, then that might create a problem.
Again, I struggle to see what he means here, because if I had been brought up all my days as a Londoner and I loved the city of London from birth, why shouldn't I make a gift that my assets be distributed among whoever the trustees wish, who are residents of Greater London?
Well, look, I entirely agree with you. For the purposes of today, that I don't actually have to sort of say whether that works or not. The point that's being made against me is that this is supposedly, these dicta, you have to read the case as a whole, look at them against the other cases, are dicta saying you cannot have a trust, which is for any persons whom the trustees select except for themselves. And in our submission, that is not what Barden is saying, and indeed it's inconsistent with Barden.
Yes.
I mean, I can see it might be unworkable as opposed to conceptually uncertain if what the trustees are obliged to do is to survey the whole field before picking a particular person, because you don't know, because of the administrative unworkability, who actually is within, even though they could, in conceptual terms, the main point of Barden, come forward and say, yeah, I've lived in London all my life, here's my council tax statement, and the evidence would be conclusive. So, anyway, but you've probably helped us as much as you can.
But the critical point, though, we mustn't lose sight of, and it really is critical. The point in Barden was, is there a distinction between trusts and powers? And the House of Lords firmly stamped on that. That is a heresy that has gone. Once you recognise that, you then see lots of cases which say, if you have a power to, for instance, to distribute the fund to such persons as you see fit, except for X, that's perfectly fine. And it would be entirely inconsistent with the House of Lords decision in Barden to say, therefore, as is said here, that a trust, if you construe our trust as saying, well, it's for anyone who the trustees select except for X, that is invalid. In our submission, that is contrary to Barden. My Lord, can I then go on to consider the article which has been referred to on a number of occasions and has really come at the forefront of the submissions in this court in many respects, which is the article by Professor Lionel Smith, which is at page 2956. Now, I imagine everybody's read it, and so, or if not, you will.
It's on my reading list.
I was going to say, well, it make good bedtime reading, but no, I don't mean that in a pejorative way.
I won't be reading it in bed.
But it is, and as I say, I'm pleased to see Professor Smith here. It is an interesting and thought-provoking article. But with respect to Professor Smith, well, I would suggest it's a very limited assistance to you. Now, first thing I want to make good is that Professor Smith, in the article, is saying that Barden and Schmidt are wrong. And why do I say that? And you were taken to it, no one has pointed this out, surprisingly, but if you go to footnote 20, which is on page 2961, and you'll see at footnote 20, he says that in MacPhail, the House of Lords held that Clause 9A of the Trust Deed created a discretionary trust in the narrow sense. The terminology of discretionary trust was used in argument along with alternative trust power, which is another way of capturing the obligation, the combination of obligation and discretion. Lord Wilberforce called it both a trust power and a discretionary power. As is well known, the holding by the majority of 3-2 was that for a discretionary trust in this narrow sense, the applicable test for certainty of objects is individual ascertainability, so that it's not necessary to be able to compile a complete list of beneficiaries of such a trust in order for it to be valid. The dissenters may well have had the better of the argument. Is it possible to owe legal obligations relating to the benefit of property to all members of an unascertained class of persons? I'll come back to that point. As to Schmidt, if you go to footnote 16, which is on page 2960, you'll see what he says in the middle of footnote 16. I will argue below that the reasoning in Schmidt is doubtful as its authority in English. It's footnote 16.
Sorry, thank you very much.
Oh, sorry, 2960, I apologise. And it's the third sentence. I will argue below in the section rights to information that the reasoning in Schmidt is doubtful, as is its authority in English law. Now, the next point I want to just highlight.
That's specifically in connection with whether objects of powers have standing to enforce.
Well, it goes beyond that, because the thrust of his article is that the only people who have rights to enforce a trust are the beneficiaries, and he would say the default beneficiaries.
Yes, well, that fits with that. Yes.
Yeah. So it's. I know yesterday we had a discussion where we're trying to limit Schmidt, but Professor Smith is recognising Schmidt isn't. You can't just limit it and say, well, it was just about getting documents. It's about who's actually entitled to enforce the obligations. Again, I do urge on you to be cautious about trying to, as it were, sideline a case like Schmidt. Now, the next point that is important to note is what was Professor Smith actually doing in this article? What he was interested in doing, and nothing wrong with that, he was interested in identifying what he calls legal risks. What he means by legal risks, he explains at 2956 in the right-hand column. So he says, you'll see about 3 lines down, he refers to these trusts that first became popular in offshore jurisdictions but have now moved onshore. The goal of this article is to identify a range of legal risks that may arise from this style of trust drafting. I use this term legal risk in a broad way to cover risks arising from uncertainties about the law as well as risks of litigation. So what he's saying is, well, I can see arguments, we're seeing some of the arguments raised in this case that may arise, but that doesn't mean that that is what the law is when you've got cases such as Barden and so on, and indeed Schmidt. Now, the overarching flaw in our submission in Professor Smith's article concerns his definition of a beneficiary and his conception of the beneficiary principle. And you can see at 2958, he says that every trust I'm just trying to find the passage. Yes, in the left-hand column, he says the obligation between the two senses is that every trust structure, every trust in the wider sense, must include at least one trust in the narrow sense, which is an obligation with respect to the benefit of the property held in trust.
I'm so sorry, I've missed where you were on the...
Sorry,
Yes. 4 lines, 3 lines down, left-hand column, 2958.
Yes.
All right, thank you.
It's the first... You'll need to read... Oh, so you'll read the whole article. But his thesis is that you have to have an obligation with respect to the benefit of the property, and he says that there is no... trust further down, about 5 lines further down, beginning, there is no trust unless there is a beneficiary. To say that the trustee owes an obligation with respect to the benefit of the property is to say that someone is owed that obligation. So his definition of beneficiary is someone who's owed an obligation with respect to the benefit of property. And what does he mean by beneficiary, which he refers to beneficiary in the strict sense? At 2959, in the left-hand column, about 10 or so lines down, there's a sentence, the beneficiaries in the strict or correct sense and as a matter of trust law are the people who will get the trust property if the discretions held by the trustees or others are not exercised. So on that definition, Professor Smith's definition, objects of powers are not beneficiaries and cannot satisfy the beneficiary principle.
Yes, this is a reference to the Schedule 3 default beneficiary.
It's right. He's saying it's the only people who have any obligations owed to them, the only people who can enforce the trust, he says, are, as your Lordship says, the Schedule 3 default beneficiaries. So that is his narrow definition of beneficiary, and someone who is at the time owed an obligation in relation to the benefit of the trust property, therefore excluding objects of powers. Now, that submission or that proposition is inconsistent with the majority view in Barden, because the majority, and that's why Professor Smith says he prefers the view of the minority. Barden was concerned with a discretionary trust, in other words, a duty to distribute capital or income among a class with a discretion as to which members of that class to benefit. In Barden, the majority held that the trust satisfied the certainty test, in other words, what Professor Smith calls the beneficiary principle, even if the class of beneficiaries cannot be exhaustively ascertained. Now, Professor Smith's definition of the beneficiary is, with respect, I mean, that is the premise of the article. And the premise of his argument and the overarching flaw, I mean, is that it's premised upon the minority being right in Barden. Now, academics perfectly entitled to have that view, but as I've already said, that's not the law, and Barden has stood as good law for some 50 years. Now,
just out of interest, in Barden, McPhill and Dalton, were the statements that the discretionary objects of the trust were entitled to enforce? You may well say it's implicit in the reasoning. I just wonder if there's any express statement.
Yeah, well, Schmidt decides that. That's what we say Schmidt is deciding.
Right. I mean, Schmidt was deciding a sort of, well, what might be said to be a degree of enforcement prior to actually appointment, because it was about information regarding the trust. Again, you might say it's all the same thing. I'm just trying to see what statements there are.
In Schmidt, though, I do say it's all the same thing, but Schmidt would be it would be a very surprising decision if you say that the person who you recognise is likely to be the object of a power. In other words, is he within the people who are really intended to benefit, even if not yet a beneficiary? If you say, well, they can come along and get information, and the court will give that, but they couldn't come along and say, oh, court, by the way, that trustee has been pinching the money, can you make him put it back? Because that would be the conclusion. You'd be saying, well, the Privy Council in Schmidt says, yeah, you can come along and get some information, but you don't have any standing to say to the court, make him put the money back.
And I follow the force of that, but is the short answer to my question, no, there aren't express statements about
I can't
beyond.
No, I mean,
in Schmidt there are express statements in Schmidt, but I don't recall in Barden, in answer to your question.
Barden is concerned with a quite separate question, namely whether there was a valid trust at all.
Exactly. But in Schmidt, there are dicta which actually do address that.
And I think in Schmidt, Mr. Schmidt had already commenced proceedings in his own name, as well as PR for his father, seeking to hold the trustees to account. And the application in Schmidt was not an application for discovery in those proceedings, but was seeking to exercise a right of a beneficiary to access trust papers, and that was the issue for the House.
That was the issue for the House. The whole premise was that he was somebody who was entitled to come along, not simply, as it were, as a bystander, say, oh, I'd like to know what's going on. The reason is because I'm going to enforce, I have standing to enforce the trust, in the sense of saying, to come to the court to say you must remedy the breach of trust.
Yes, I can't recall whether the Lord Walker went so far as to say that. Because in a sense that wasn't quite the issue. I mean, I take the point that you make, that, well, what's the point of being able to have access to documents and information if you can't then use them to enforce the trust?
Yes.
But I can't recall whether Lord Walker actually said that.
Yes.
Well, I mean, I think in paragraph 33 at 2421, what was said was that in relation to the Everest Trust, in his personal capacity, he was no more than a possible object of a very wide power to add beneficiaries, but he had a particularly strong claim.
Can I take you? Let's go out of this article and go to Schmidt, because and I'll show you how, in fact, Yeah, yeah. Yeah, sorry, I'm jumping around, and my learned junior has correctly told me that Professor Smith actually makes the point. Hang on.
Shall we look at that first?
Where do you want me to go? Where? Where does it say that? Oh, yes, yes. In the Professor Smith's article, you see, yes, in page 2959. He says objects of powers don't have any right to any property. Perhaps less obviously, they don't have a right to enforce the trust. This is just saying the same thing in a different way, because the trust in the narrow sense is the obligation relating to the benefit of the trust property. Or in other words, just skipping on, since objects of powers don't have the right to enforce any trust property, they cannot enforce obligations. And then he goes on to say, it refers to manusty, saying that their rights are limited. But he then goes on at 2959 to say that at the bottom of the page, this might seem surprising. If a trustee had misappropriated property or made negligent investments, or was about to enter into a transaction in a conflict of interest, or had secured an unauthorized profit, should not the object of a power have standing to complain? Now, just stopping there, I would say the answer to that, Professor Smith, is obviously. What he says is, interestingly, there seems to be no onshore authority that affirms such a proposition, and a moment's reflection shows why this is the case. And just stopping there for a moment, what he means by no onshore authority, in other words, he's saying Schmidt is authority for this, but that's not onshore. That's because it's the Privy Council. The object, by definition, has no right to any right of the trust property. All of the actions that a beneficiary may take are related to the proper administration of the trust, and so on. Now, the passage in Schmidt that we should look at, yeah, so what's the page of Schmidt? 2439. 2429, I'm sorry. Yeah. 2429. Yeah. Yes. If you go to 2429, sorry, this is the passage I wanted to show you. At what you need to read is, and I haven't got time to read it to you, you'll need to read paragraphs 56 to 60. And what Lord Walker does is at paragraph 59, he refers to a decision from New South Wales, where, and you'll see in the quote at D, that the question then is whether a person whose status is only of that of a potential object can properly be regarded as one of the cestui qui trust of the relevant trustee. And there it was said, I don't doubt he can and should properly be so regarded. And you'll read the rest of it. And then at 60, he says, the staff of government division quoted the above paragraph from the judgment in Spelson and George and criticised him for giving no reasons for his extension of the discretionary object's rights to require the trustees to account for their trusteeship. Their lordships regard this criticism as surprising and unwarranted. And so it is certainly part of what Lord Walker and the Privy Council was saying in Schmidt, that the object of a power does have the right to require the trustees to account for their trusteeship. And that is, Now, because of the shortness of time, I will just give you a couple of other references. But an important reference on this point is to a Jersey case called Freeman and Ambasher, or Ansbasher, I think it is. And the relevant part is set out in an article by Professor Nolan, which you have at 2915. And I'd commend to you reading pages 2915 to 2917. And you will see in that case that there was a concession, a considered concession of counsel for the trustees in that case, one Michael Briggs QC, that the object of a fiduciary dispositive power may enforce the obligation of the trustees, a concession considered and which the court agreed with. Sorry, where are you?
Yes, because there's no need to show loss in order to enforce the trustee obligations.
That's right. No. You don't have to show that you've suffered a personal loss. But the premise of Professor Smith's article is that you actually have to have an interest in the property.
I understand.
And so you would have to show that, even if it's a contingent interest, but you have at least suffered the loss of what you would be entitled to if your interest wasn't defeated. Whereas what Michael Briggs's counsel was conceding, what Lord Walker, sitting in this court, was saying is, no, that's not right at all. You don't have to have an interest, and you can come along, you have the right to go to court. And in Mr. Vadim's, or Vadim the son's case, if you are just somebody who we recognise is likely to be somebody who would be within that power. Obviously, if you have a trust which is for anybody in the world except X, and somebody from Peru turns up, I don't mean Peru pejoratively, but like in the Paddington Bear from Darkest Peru, turns up and says, well, I'm interested in this, the court might say, well, you're just an officious person, you've got no real interest. But assuming you have got some prospect of receiving money or payout or interest, then you do have a right to come along to court.
I think the case where Michael Briggs QC made the concession was at Limos and Coots, Cayman, rather than Ansbacher.
That's right. Sorry, but it's referred to in the Freeman and Ansbacher case, yes. I think. Sorry, if I misled you, I apologize.
I may have misunderstood you.
Yeah.
I mean, the point you're just making just made me wonder whether there was something more in MacPhail and Dalton, because their Lord Wilberforce says that the court can enforce, can exercise the trust, exercise the discretion itself, if need be.
Yes.
I would have thought that it's then really a question of literally a question of standing. Who's entitled to come to the court to ask it to exercise that power? And
well, of course,
it would be a bit strange if an object couldn't come to court.
Exactly. I mean, that's why this thesis that that the default beneficiary is the only people really with an interest in our submission is simply wrong. Mm. Sorry, what is it? Because we're running out of time.
That's fine.
Yeah. Now, my lords, because I'm... that's what I wanted to say about these sort of overarching legal principles. Now, what I want to come back to quite quickly is, where does this get us? I mean, obviously, that's an important point. Now, and to take stock. Now, what is common ground, I think? Well, subject to these points which I say are misconceived, the purpose of a power is the purpose for which this set law objectively created it. But the important point that I've sought to get across to you this morning is that it is entirely wrong to, as it were, be approaching this as I perceive that one might have been doing, with an a priori view as to how these things are to work. That is not the case at all, any more than you approach the construction of a contract with some a priori view. You construe it fairly and properly in its, according to the words used, and in its context, because what you're seeking to do when you construe a contract and when you construe a trust is to ascertain what it was that the settlor intended. Now, putting to one side these legal issues which I've addressed, what is it that is said in this case? The appellants invite you to hold that the purpose of the Global Resource Trust was to benefit the existing beneficiaries alone, namely the children and issue of the founders, that's Tony's case, or the Wang family alone, which is Winston's case. Now, and that the purpose of Clause 8 is only to add people who will, in Tony's case, further the interests of those who are the existing beneficiaries at the time that you add it. And in Winston's case, I think he espouses that, but he also says, well, you also just have to be a member of the family, whatever definition he chooses to give to that. Now, where does any of this actually come from? It's founded on two things, and two things only. One is...
Can I just sort of interject?
Yes, of course.
Given what Lord Wilberforce said about relatives, in quotes, is not the same as all residents of Greater London, I don't understand you to be taking a point that to say the class of potential additions being a member of the family would be too uncertain.
No, I'm not taking that point, my lady, but I do take the point in relation to Winston's case that there's absolutely nothing to say that this is limited to...
No, I understand that.
Yeah.
But I'm not taking an invalidity...
What I'm saying is, the uncertainty point is, if you're trying to construe this trust deed to say the power of addition was limited to someone who has some sort of relationship to the family or some other definition of Wang family, where do you get that from? And what does it actually mean? I mean, it's fine, it's been conjured up for the purposes of argument, but it's nothing more than that. Now, what I wanted I need to deal with is, well, where do they actually get this from? And what you've been confronted with is two points they make. One is by reference to Schedule 3, and one is by reference to Schedule 2, and a combination of the two. Now, let's just examine that, if we may. The significance of Schedule 3 first. The problem we suggest the appellants face is that default beneficiaries, whoever they are virtually never expected by the settlor, in fact, to benefit from the trust. Now, why do I say that? And these are points I've to some extent already made, so I'll take them quickly. Take the situation where the default beneficiary is a charity, as we see in some cases, very, very frequently, or some random person, a partner of Freshfields. I don't mean they're random in a sort of derogatory way, but I think you know what I mean, but with no connection to the settlor. And I should make it clear, I have the highest regard for Freshfields sending me their work. It is obvious that the settlor's purpose in creating the trust is, in those situations, absolutely obvious, is not to benefit the default beneficiary. Schmidt, Sofa are good examples. Another case that we've referred you to is the Gaia settlement case. Perhaps, right, I think I'll just give you the reference. I don't have time to go to it, but it's 6854. You'll see the paragraph beginning, the beneficiaries of the settlement are. So if you take that case, you simply have a power of addition. It couldn't sensibly be argued that, and let's say it's a power of addition in exactly our words, it couldn't sensibly be argued that it was intended that should be exercised in the interests of the default beneficiaries. Now, appoint my lady...
Have your page reference again? I'm so sorry.
Sorry, 6854.
6854.
Yes. No, I think that's the right reference. I'll ask.
Yes.
Yeah. Now, a point that my lady, I think, made yesterday was, well, this is different because here the default beneficiaries are the same people, or more. They're not the same people, but they're because it's obviously
The named ones are the same.
Well, it's not the same people in this sense. You've got to be a child who is going to be alive in 100 years' time, so virtually impossible. Not, I mean, if you were a child, I mean, bearing in mind these were two 80-year-old men or thereabouts, I don't think either of them had infant children. I think their children were minimum of in their 30s, 40s, and 50s. It'd be pretty unlikely, even with advances in medical science, that any of them were going to live. So, but that's not my point. The key point is, even if they are, let's say they were named individuals to make it simpler, there are two reasons why you are very unlikely to intend to benefit them as default beneficiaries. And the reason for that is that default beneficiaries, by definition, only receive what is left of the trust fund at the end of the trust period. So it follows that any exercise of dispositive powers in the trust, such as a power of appointment, is necessarily against their interest. So it cannot be the case that you have to exercise powers during the life of the trust in the interests of people who might get the residuary at the end of the trust, because the whole purpose of the trust is that you're going to be doing this.
I do think you have to be a bit careful with that argument, because that's going back to, the sort of the Lewin point that any exercise of a dispositive power must be against the interests of the beneficiaries.
It is against the interest of you as a default beneficiary, because anything that is done during the life of the trust will stop you receiving anything as anything that's distributed, you can't get in your capacity as the default beneficiary.
All right, so you say the argument works, but only because you say you're concerned with the capacity in which you're going to get the...
Well, what I'm saying is if one asks, we're asking, my Lord, again, we have to be careful we don't go off at a tangent. One's asking, why are we considering this? What is the purpose of the set law when he gives the power of addition? The point I'm making is that the set law, when he gives the power of addition to add beneficiaries, when he gives a power of appointment, cannot be intending that you exercise, for instance, the power of appointment under 3 and the power of distribution under 4 in the interests of the default beneficiaries. Because what the set law overall intends is that the trust fund during the 100 years will be distributed. And so those default beneficiaries are only there in case that doesn't happen. Anyway, your Lordship has Lordship and Ladyship have my point. Now, so we suggest that it would be wrong to suggest that fiduciary powers in the trust can only be exercised in the interests of the default beneficiaries. And just to sort of pick up the point I think my Lord Sales was making, there may be circumstances where there is a coincidence. In other words, you can say, well, it is in the interest of the default beneficiary because they are the same person. But you've got to remember, the default beneficiary is actually including children yet to be born. Now, how is it going to be in their interest, or infant children, how is it going to be in their interest to distribute the monies to the existing generation, which may happen? I mean, I
don't want to prolong this.
The point is, all I'm saying is the trustee doesn't have to be saying, how does this benefit them? That would be...
I follow your argument to that extent. I mean,
yes, in many cases, the exercise of a power in favour of an object will prejudice the default beneficiary.
Exactly.
There may be some cases where it won't.
Exactly. That basically summarises.
But I thought we'd moved on to a different point, which was whether accepting that there are cases where there's a random person of a very prestigious law firm,
Yes.
who is named as the ultimate beneficiary, and one can assume from that that they were not intended to benefit, whether that is an assumption that you always make, even when actually the people named as the ultimate beneficiaries are a much narrower, connected, not random group, and you say, well, even then, they're not really directed the direction of the bounty because this is going to last for 100 years and the expectation is that all the money will be dealt out before that time.
Yes, I mean, my point is that what we're asking is, when you exercise a power, has the settlor in this trust, or any of these types of trusts, but take this trust, can one seriously say that what the settlor intended, that you must always have account of the interests of the default beneficiaries? And in my submission, that the reality is this is a 100-year trust, and the trustees, the purpose of the trust is to exercise the powers in 3 and 4, and it's only if you fail to do that they ever get anything. And so it would be turning it on its head to say that during the life of the trust you've got to take account of their interests. That's all I'm saying.
Yeah, I'm not sure the other side was saying that. They're not looking at this point of the argument about the default beneficiaries. As I understood the argument, Richard Wilson's argument, it was the Schedule 2.
Yeah, my lord, I'm coming on to Schedule 2.
I think both arguments were advanced against you.
They do run both, and so I need to knock out.
Yes.
First, I'm going to come to Schedule 2 now.
Yes.
But I just wanted to show. What I meant was, my lord, Lord Barrows, all I'm saying is that if one asks in the trustee, what is it anyone's saying shows this is a trust which is only to benefit those people who are named. Where have we got them named? We've got them in Schedule 3 and Schedule 2. So that's my point about Schedule 3. So if Schedule 3 doesn't give you this, doesn't impress on this, that when you exercise the power of addition, we then have to go to Schedule 2. And you have to ask yourself, well, what is then the dividing line on Schedule 2? Now, our case is that the definition of beneficiaries, which the settlor chose, we say, that it is to benefit such persons as the trustee may choose from time to time to be having regard to the concept of the settlor's bounty. Now, the appellant's case is no, it is only to benefit the Schedule 2 beneficiaries and or, I suppose, the Schedule 3 beneficiaries. Now, what's important is there is no rule of law that a settlor cannot create a trust for such persons as the trustee chooses from time to time. So then what you've got to do once you realise that is to ask, well, what was the purpose for which the settlor created this power? Now, in our submission, and this is a point that one does need to look to dwell on for a moment, the Clause 8 power on the case that's made against us would either be effectively and practically, or at least largely redundant, if it could only be exercised in the interests of the existing Schedule 2 beneficiaries. Now, why is that? Now, could we go back? You need to get out the trust deed in order to follow the point. It is at page 364, or you probably have it loose, and we need to have open 367. Now, we've had a lot of discussion in court and between the bench and the bar, and particularly with me, about, well, what if you wanted to benefit a partner of a child or a charity? Isn't that what Clause 8 is all about? Now, that overlooks this. if you want to benefit if you want to make a payment or set up a mirror trust, which is for the benefit of someone with whom the child who's within Schedule 2 has some moral obligation or some interest, you can already do all of that. You can do it under clauses 3 and clauses 4. Because under clause 3, we've already looked at this yesterday, you can exercise your power of appointment in favour of or for the benefit of the beneficiaries. So that includes, the words for the benefit of, would include making payments to people with whom they had moral obligations or for their in some relationship. Also, it's a very wide expression. Equally, the power of distribution can be exercised to or for the benefit of the Schedule 2 beneficiaries. So if the appointment or distribution of the trust fund to a third party was sought to be made, who was not an existing Schedule 2 beneficiary but would be in the interests of an existing Schedule 2 beneficiary, that can be done under clauses 3 and 4. So you don't need any exercise of the power of addition in those situations. Now, the appellants, as we understand it, don't dispute that. Mrs. Talbot-Rice accepted below that if making a distribution to a charity would be in the interests of an existing beneficiary, that distribution...
Sorry.
Just bear.
Apologies.
No, not at all.
One of the dangers of using technology.
Yes. Well, I have to say I'm in admiration that you're all able to entirely use the electronic bundle. I'm old-fashioned and still stuck with paper bundles, but I think, having seen this, I think I'll try and improve.
COVID forced it on us.
I was referring to the submission made below.
Using that the appellants don't dispute the fact that clauses 3 and 4 could be used for those purposes.
Yes, and that was a submission made below 1386, lines 12 to 16, that you didn't need to add the charity. So if the purpose of the power of addition is to add persons as beneficiaries only when that is in the interests of an existing beneficiary, clause 8 would be redundant, because the only thing that the appellants say you can do under clause 8, namely benefit a non-beneficiary where that's in the interests of an existing beneficiary, you can do in any event under clauses 3 and 4. And I ought to deal with this. It might be said, well, there's a circumstance where you do need clause 8 to do something that clauses 3 and 4 don't do. So suppose, for instance, one of the Schedule 2 people has a spouse or unmarried long-term partner. While the child is alive, the trustees can, on Tony's case, make a distribution to the spouse or partner under clause 4. But once the child dies, once the Schedule 2 person dies, it might be said, well, can you benefit the widow because the Schedule 2 person is no longer a beneficiary as defined? Now, the answer to that is you can, because if you were interested in ensuring that, for instance, some person who was in a relationship with a child, with a Schedule 2 person, should get the benefit of the trust. Under Clause 3, the power of appointment, you have the ability to set up a mirror trust with the same beneficiaries plus another. And that's essentially what the Blouston case is authority for at 4138. Now, I don't have time to go to that, but in our submission, that is, in that case, what happened was one of the objects was, they used the power of appointment, which was the same as the power of appointment here, or essentially the same, and they set up another trust where they deleted one of the objects, which was the wife, because of a change in tax law. Now, that was a deletion, but there's absolutely no reason why you couldn't make an addition, and taking the case that is made that you have to exercise that power in the interests of the existing beneficiary, if there's a relationship, then you can do it. So we say that...
But I thought your case was that you don't need to exercise the power for the benefit of the...
No, my case is, but what I'm testing is whether...
There might still be a use for a power which is limited, a power in Clause 8 which is limited to family members, quasi-family members, who can easily be added to the Schedule 2, capital B beneficiaries, even if it's arguable that it's not for the benefit of the existing beneficiaries.
But got to remember, wait a minute, there's an inconsistency.
What I'm saying is that it doesn't seem to me to be just a binary choice between only being able to add people if they can be said in some way to benefit the existing class of beneficiaries and the whole world.
Well, it is a binary choice in this sense. The other side's case, the case I'm meeting, and the restriction that they're putting on this, they say you can only exercise the power in 8 of addition if that is in the interests of the existing...
But you say that's not the case.
No, I said that's wrong. What I'm testing, sorry if I didn't make it clear, I'm testing, my submission is, as you know, is that Clause 8 is a wide power and it doesn't have any restriction. What I'm simply saying at this stage of the argument is that it would be surprising if you say Clause 8 has this, is limited, when if what you are interested in is benefiting some people like a widow, partners, that you can do that already under Clauses 3 and 4. And so what I say is it is more likely that Clause 8 was intended, particularly because one finds that is incorporated effectively in the definition of beneficiary, that was intended to give a broader power to cater for any change of circumstance. And the way it's put in one of the cases, or I think put in the Court of Appeal here, that the purpose of this is to put the trustees in the position that the set law was in when he created the trust. So that is why I don't shrink from saying, is this the equivalent of a trust for anyone in the world except X? It is, because that's what the definition of beneficiaries is. The definition of beneficiaries is these persons subject to the exercise of the powers in Clause 8. And those powers are intended to be in unrestricted terms. And
can I just follow, yes, though, my Lady Rose's point?
Yes,
because your criticisms at this point seem to me to be directed entirely at one set of arguments being put by the other side. That is the arguments put by Mr. Wilson.
Yes.
But there was the alternative approach being put forward by Mrs. Talbot-Rice, yes, that doesn't turn on whether you are benefiting, acting in the best interest, yes, of the beneficiaries, but is rather concerned with the underlying purpose of the trust, yes, which is this Wang Family Trust.
Yes.
I think that is my understanding.
I appreciate it. Yeah, I'm addressing at the moment, but the two interrelate. Once, if
well, they don't, in the sense that Mrs. Talbot-Rice is not suggesting that you have to be acting in the best interest of the beneficiary.
No, she's not. But the two interrelate in this way, my lord.
Well, there's an overlap between the fundamental purpose argument, yeah, that's been put forward on the one hand and the substratum on the other.
Exactly. Well, if you then come back to, my lord, on the so-called substratum point.
Well, that's the separate point, isn't it?
It is, my lord. But what I'm saying is, then the analysis of whether we said there is no substratum principle.
I realise that.
And I haven't got time to go to the cases, but right, we say it's all a matter of construction. and we've addressed it. But even if there is a substratum principle, in other words, if you're trying to say, well, what is this, whatever that expression means, substratum, what is the overall purpose of the trust? You come back to, well, how are the powers meant to operate? What is the relevance of Schedule 2 and Schedule 3? You come back to that question, is this simply meant to be a trust to benefit Wang family members? Or is it, as the Court of Appeal said, no, it's actually, that's where it all starts. But actually what the settlors intend to do is to give the trustees a power, which means it is actually, there's no substratum in the sense that Winston puts it. As the Court of Appeal said, there is a roving class of beneficiaries. And we say that is right. Yeah, and can I, because I need to say something about issue 2, I want to just show you one other authority, because I think it is actually helpful in this. It's at page 6834. And it's a helpful dicta in a case called Dion Investments. At paragraph 45.
Which court is this?
This is in the Court of Appeal, or the Supreme Court of Appeal in New South Wales.
Okay.
And
who's the judge giving the judgment?
The judge, is, yes, it's Justice of Appeal Barrett delivering the judgment, and the President was Beasley and Justice of Appeal Gleeson.
Right. Thank you.
And they agreed. But it's just that the dicta at 45 are a pithy summary of what I suggest is the position. So you see at 45, they say, where the trust instrument contains a provision allowing variation by a particular process, the situation is one in which the settlor, in declaring the trust and defining its terms, has specified that those terms are not immutable and that the original terms will be superseded by varied terms if the specified process of variation, entailing in concept of a power of appointment or a power of revocation or both, is undertaken. The varied terms are in that way traceable to the settlor's intention as communicated to the original trustee. And that, in my submission, picks up the point that if we're right that Clause 8 gives the broad power to the trustee, then that is what the settlor intended. One's not undermining the settlor's intention. One is, in fact, giving effect to it. Now, I'm now going, unless there's anything else on issue 1 I can assist you on, I'm going to move briefly in the time that's left to issue 2. And I can take this point briefly because we suggest these points are really pretty hopeless. There are 3 points we make. First, the proviso to Clause 9, on which the appellants rely, did not apply to the distribution of the trust property to Grandview. Secondly, even if that proviso did apply, the distribution vested immediately. So there was no prospect that it would or might infringe the remoteness of vesting rule. Thirdly, even if the proviso would otherwise invalidate the distribution, it was disapplied by the distribution itself. Now, if we're right on any of those points, the appellant's argument fails. They have to be right on all 3 of them, and we say they're in fact wrong on all of them. Now, I want to start in the middle, as it were, simply because that is the more, well, I suppose it's more complicated, but it's important to get this concept clear, which is vesting, because there are 2 different rules, which I think everybody agrees you mustn't conflate, but it is very easy to conflate and muddle them. The excessive duration rule is the rule that a non-charitable purpose trust cannot be indefinite in duration. It must be limited to the perpetuity period. It's therefore a rule about the duration of trusts. You can see that rule set out in Maudsley at page 7890. The remoteness of vesting rule is different. It is not a rule about the duration of trusts or the duration of interests. It's concerned with the commencement of interests. In simple terms, the rule is that a contingent future interest in property must vest. That is to say, it must cease to be contingent or conditional within a certain period of time. That period of time is, of course, known as the perpetuity period. That statement of the law can be found in Morris and Leach, page 7988, quoting the classical formulation from Gray's. Now, how does vesting work? It's important to understand what it is that must vest. So a vested interest in trust property is an interest in trust property that is not subject to any condition. By contrast, a contingent interest is, and to quote Lewin at page 8245, paragraph 1-055, is an interest which may become a vested interest, but is dependent for that transformation upon a future event or occurrence. So in simple terms, the remoteness of vesting rule is concerned with the period of time within which a contingent or future interest must become a vested interest. And that point is worth emphasizing because it shows that the rule is not engaged at all unless there is a contingent or future interest at the beginning of the story. If there isn't, then there is nothing that is capable of vesting in the future, and the remoteness rule is simply not engaged. So if you take the example of a private discretionary trust, the type where there is an obligation to distribute, but with a discretion as to who gets and how much, in that case, each member of the class has a contingent or future interest in the trust property. Now, because there is a future interest in the trust property, that interest must vest within the perpetuity period. Otherwise, it is void for remoteness. And again, you see that explained in Maudsley at 7888, internal page 1112. Now, the question that we suggest one first needs to ask, if property is distributed unconditionally to the trustee of a non-charitable purpose trust, does that give rise to any future interest? The answer is plainly not. Why is that plain? And we say plain as a pikestaff because a purpose trust does not have any beneficiaries. No one has a future interest. That is so whether the purpose trust is charitable or non-charitable. Now, of course, various persons or entities may receive a distribution from the property of a purpose trust, but that does not make them beneficiaries of the trust. That's explained by Lord Millett in the Latimer case at 4346, paragraph 29, by Mr. Justice Brightman in London Hospital, page 4426. Now, recognizing this difficulty, my learned friend accepts that if you have a trust for what he calls wholly abstract or impersonal non-charitable purposes, then, in that instance, nobody has an interest that is capable of vesting. But, he says, a non-charitable purpose trust which could benefit persons is different, he says, and should be treated like a private discretionary trust. Day 1, pages 125 to 127. So he seeks to draw a distinction between two types of non-charitable purpose trusts. With respect, the distinction is utterly misconceived. Whatever the nature of the non-charitable purpose, whether impersonal or otherwise, the point is it is a purpose trust, not a trust for persons. Bermuda has changed its law to allow you to have purpose trusts. A purpose trust, the whole rationale of it, is it has no beneficiaries. Now, a charitable trust may also, and indeed often does, benefit persons as a matter of fact. But it is well established that the remoteness rule is not engaged because nobody has any interest in the trust that is capable of vesting. Let me give you a very simple and obvious example.
So as I understand your submission, you're really just saying that just as the remoteness of vesting rule does not apply to charitable purpose trusts, it also, by definition, does not apply to a non-charitable purpose.
It's as simple as that, yeah.
Yes.
It's as simple as that.
Well, but you have to go a bit further to say, and it's still entirely a non-charitable purpose trust, even though there are named people who can benefit.
Well, yes, we're talking about the purpose trust we're talking about now.
It's the WFT.
I'm sorry?
It's the WFT.
Yes, there are no named people who have any rights.
Well, perhaps we could we just go over it? I know you're pressed for time, but...
Yes, no, I'm going to go to that in a moment. But the Wang Family Trust is a purpose trust to carry out the vision of the founders. I'll show you, there are no beneficiaries of the Wang Family Trust. I mean,
Except possibly the companies themselves.
no, they're not beneficiaries of the Wang Family Trust.
We won't go into the argument now because it doesn't arise, but it's all for the benefit of those companies.
The purpose of the trust is not to provide a benefit to them. I mean, it's only like saying the British Heart Foundation or Oxfam.
It's all to perpetuate the companies. That's the principal purpose is. Give it a competitive edge.
Yes.
See it going on into the future. It seems.
But it's to do that, but it's not that they don't become well. It probably doesn't matter for present purposes. They don't have any rights. They never get a vested right in property or anything of that sort.
That's true.
I mean, there's no difference between the example I was going to give you was the British Heart Foundation paying for somebody's treatment in hospital. The person getting their hospital treatment paid for is not a beneficiary, or when Oxfam pays for somebody to dig a well in a village in Africa, you wouldn't say that the residents of the village were beneficiaries of the trust or anything invested in them, or if they're given money. None of it, in our submission, is a complete misunderstanding. Somebody getting money out of a purpose trust doesn't become... Yes. I mean, just to pick up the point that actually Sir David Richards made, it might be worth just reminding you of what was said in the Latimer case at 4346, paragraph 29, in the Privy Council by Lord Millett, delivering the judgment to the board. And at 29, he says, it's of the essence of a charitable trust that it is a trust for the promotion or advancement of social purposes rather than a trust for individual beneficiaries. Of course, individuals may benefit from the application of trust monies, but they are not, as individuals, the beneficiary of the trust and may not enforce its terms. And
I mean, all this is quite difficult from our perspective in one sense, isn't it? Because we're so used to non-charitable purpose trusts not being valid. And part of the explanation I had always understood for why perpetuity doesn't apply to charities is because they are charitable purpose trusts. But you're saying, actually, there's a conceptual reason, which is that there's no vesting in any particular individual in any event, and that applies across,
and
whether
also
you've got charity or not.
Needs not to confuse excessive duration and remoteness of vesting.
Yes.
The remoteness of vesting rule does apply to charities, but it applies in this sense. If you make a gift to a charity, but which is dependent upon some future event. So if I say I'm going to leave £1 million to Oxfam, dependent upon whether or not something else happens, then Oxfam in that instance has a contingent right to the fund, and if that contingency isn't certain to happen within a perpetuity period, then that may be void. But so it still applies, but it's just once the gift vests in the charity, in the trustee of the charity, the fact that the trustee may dole out monies here, and there, that's got nothing to do with the rule of remoteness of vesting, because the persons to whom you dole out the money have no interest in the beginning that is then becoming vested.
So it vests in the trustee immediately that the gift is received.
Exactly.
And you say that that is the same for a non-charitable purpose trust, which is not invalid because Bermudan law permits it, as it is for a charitable trust.
Exactly.
Yeah.
We say that that's why this is all...
Mr. Hurd, Lord Burrows, I think, is probably right, that it's the public interest in charity that produced charity as an exception to the rules of excessive duration.
Excessive duration?
Yes. Now, the question then is, is there the same rationale applied to non-charitable purpose trusts? And that leads me to this question.
Yes.
Given, as we know, there are the 4 occasions on which Homer nodded, and purpose trusts are legal under English law, is there any case about these rules in relation to non-charitable purpose trusts which are allowable under English law?
The only authority that the other side pointed to was a case called Re Compton, but that is a case actually about excessive duration, not about remoteness of vesting, so that's totally irrelevant. Yes, I'll get the reference. There's also a case called Re Kane, which we've cited in our written case.
Right. Okay, and those are sort of in this area. I mean, that's all.
I think the point is this. There is a public policy about why you take charities out of the rule about excessive duration, and that's the fairly obvious public policy that we regard charities as a good thing, and therefore we have no problem with charities going on perpetually. Now, the rule about remoteness of vesting, there isn't in this regard, some special exception for charities. It's simply a question of deciding what is the rule against remoteness of vesting and how does it apply. And the rule against remoteness of vesting is concerned with the vesting of a contingent interest. In the case of a charity, there isn't a contingent interest down the line. The rule against remoteness of vesting continues to apply. It's just it applies to the vesting, as my lady said, to the trustee of the charity. But once it's got to the charity, then there's nothing else that vests in anyone else at a later stage.
But what about excessive duration?
The rule, well, that's been abolished in Bermuda, so...
That's been abolished by statute.
Yeah. So we're not concerned with that.
Forgive
Very
me.
important.
Yes.
That's why. No. These are things personally I probably had never before doing this case thought about. I surely should have done when I was at university, but didn't.
Yeah,
but
I had forgotten about the Bermuda provision. Thank you. You did tell us. Yeah. Or someone told us a couple of days ago.
Recane. Yes. So that's the important point. And just so you understand it, there's also. At this point, the rule about excessive duration in Bermuda was abolished for purpose trusts. The rule against remoteness of vesting continues to apply, but there's a problem with the other side's case, because if they were right, the effect of what they're saying is that a purpose trust actually, getting rid of the rule against excessive duration hasn't achieved anything, because of this issue they make about the way the rule against remoteness of vesting works.
That's not quite right, because they say that the wait-and-see rule can still apply for the benefit of the non-charitable purpose trust or even the charitable trust, but that's what's been disapplied by Clause 9.
Yes, but at the end of the wait and see, you then...
Yes, as I understood it, what they say is that Clause 9 abrogates the wait and see rule.
Sorry to interrupt. I'm not. We're talking about something different. It's my fault. I'm not talking about Clause 9 at the moment at all. I'm talking about the statute in Bermuda.
Yes. No. I'm
sorry.
I was just trying to set it in context.
Yeah. Sorry. I apologise.
No.
Please go on. Sorry. I didn't want. It's just.
No, I thought you were about to say that what we don't want to get to in this case is something that says that the WFT trust is void for perpetuity. But that's not where we get to.
Well,
even if they're right in their argument that...
Well, that hasn't been submitted, and I can tell you in the main action which we tried last year, they've taken every single point they can dream of, and they haven't taken that one.
Let's get back on track to whether you're right to say that even with a non-charitable purpose trust, a gift to the trust still immediately vests in the trustee, so that there's no risk of, there's no perpetuity problem because there's an immediate vesting.
Well, if the gift immediately vests in the trustee, then it's vested, and there's no one else in whom it is going to vest in the future. That's my simple point.
Yeah.
If it doesn't vest in the trustee immediately and only at some future date, then you get into a remoteness of vesting point. And our simple point is that this doesn't arise on our case.
Yes.
And I think your ladyship was interested, and we should go to it, in the trust itself. And this is a point, this point that's sought to be argued now, it's actually a new point, is simply misconceived. The trust is starts at 378. And if you go to page 381, what you see is at recital A, the original trustee has received the initial property with the intention it should create a trust, and so on, for charitable and non-charitable purposes. B, it's anticipated that further property will be added. And then C, this trust is declared by the original trustee in order to fulfill the purposes described herein. The fulfillment of such purposes shall be accomplished to the greatest extent possibly, following and consistent with the spirit, vision, and principles of YC and YT, reflected in the following statement written by them. And you will then see their statement. I commend you to read it. It's actually a rather moving statement of what they sought to achieve. But for present purposes, you need to then go to page 3. And so what happens, if we just, the trust property, which at this stage was, I can't remember what the financial value of it was, but a large amount of shares in FPT companies, which had been either held by or for Mr. Hung, then got put into this trust, and so to be held by the trustees. Now, if you go to page 387, so they've received the trust property, they then, the clause 3, this is the purposes of the trust. And so this is actually the preeminent thing. What happened on day one? They were to take possession of, hold, control, manage and vote the shares of stock of the Formosa Group held by the trust, and to ensure the continued growth and prosperity of such companies. So that they're doing that from the moment they receive the shares. Now, what clause 4 is about, which you referred to, is investment and distribution guidelines for the trust regarding capital and income. In other words, these were investment guidelines to guide the trustees over the next 100 years as to what they were to do. But the trust began, and the purpose trust began the moment they got the property. It wasn't, and the property vested in them straight away. There wasn't something to vest in the future, nor was there some. Of course, there are acts to be done in the future, as with any, like a charitable trust. I mean, you give the money to Oxfam in order to fulfill the purposes of Oxfam. You'd also have investment guidelines as to what they're to do with the money in the meantime. But the charitable trust has commenced, the property is vested on day one. And that's what happened here. So in our submission, you never get to some issue of vesting. It's all a complete red herring.
But can you just, by expressing something as a purpose, make it a purpose trust rather than a trust for individuals? If you say, instead of naming your child as a beneficiary, you say this trust is declared for the purpose of educating and ensuring that my child makes his or her way in the world. Does that then become a purpose trust?
There isn't any dispute that this is a purpose trust. It's just not. There are disputes about whether the purpose trust satisfies the requirements of a purpose trust under Bermudan legislation. And that's going to be decided in a judgment which we should be receiving any day. But that this is a purpose trust isn't itself in dispute. It's certainly not in dispute in these proceedings. What? Yeah, and Professor Smith, in a different article to the one we've referred to, at page 8182, he makes the point that it's perhaps just worth turning it up. At page 819. 8196. Where's the point? Yeah, in footnote 86 on page 8196, he makes the point that where non-charitable purpose trusts are allowed and the rule against perpetuities is retained, the rule has to be changed from a rule against the duration of contingent interest to a rule that simply limits the duration of the trust, since in such a trust no one holds either a contingent or vested interest. That is a pithy summary of
what you're saying, yes. Yeah.
Now, so the reason I've taken you to that first is, firstly, I wanted you to be clear as to what vesting is. Secondly, my submission is that this is all a red herring. But I now go to the construction point, which is clause 9 of a trust deed. Does it actually apply at all? And we say very simply that clause 9 does not apply. If one looks at clause 9 and asks oneself, well, what is clause 9 doing? What clause 9 is doing is extending powers. Not itself the power. So what one sees is any power hereby or by law conferred on the trustees to appoint, pay, transfer, appropriate, or apply any capital to or for the benefit of any beneficiary. Now, just stopping there for a moment, you've already got the power to pay to a beneficiary. What this is intending to do is to give an extension. So it's not dealing with the situation where you're making a payment to or for the benefit of any beneficiary. And what it says is you can validly exercise the power by paying or transferring the same to the trustees of any settlement, the provisions of which are in the opinion of the trustees for the benefit of such beneficiary, notwithstanding that such settlement may also contain trust powers provisions in favour of some other person or object. Now, what's that all about? Firstly, it's not about where you have added the trustee of a trust as a beneficiary to this trust. It's not that. What it is about is a situation where you want to pay to the trustee of the trust, which is a trust for the benefit of a Schedule 2 person plus another. And the fact that it is plus another, and that might be people who are not within any relationship to, in other words, they're not people to benefit directly or indirectly the beneficiary of this trust. It's just they happen to be beneficiaries of that trust.
If one of the children gets married and is then included in a family trust of their spouse with all sorts of other relatives of that family, then you can pay into that trust even though there are other people.
But it could be something even more, much less. I mean, it could be, remember in the Schmidt case, the trust was for the deceased and other Lukoil executives. Now, so you could pay to, if you were a party to like a trust with other work colleagues or something like that, and that it's that sort of situation. And so this does not deal with our situation. Now, what is it? What did the other side say? Well, the submission, as I understand it, Mr. Hagan actually accepts that if you read the language of Clause 9, it doesn't apply. But he says, which is a new one on me, you have to apply, and I quote, flexibility in construction. Well, I don't know what flexibility in construction means.
Well, I think the point that's made against you is that if you're worried about the remoteness of vesting rule when you make a transfer to a trust which has as one of its beneficiaries a capital B beneficiary, it's bizarre that you should only be worried about it in that circumstance and not worried about it when you're making a...
There are two answers to that. The first is one has to construe, you're taken to intend what you wrote. And written here, there's no reason why one should displace words. It's quite a strong thing to say, well, what the settlor intends, I don't think makes sense, so I'm going to rewrite it, or I'm going to imply some term to get round it. And I would suggest that is, I don't say, you can't construe contracts in such a way where you say something has gone wrong, but you'd have to say something has gone wrong here. That's the first thing. But the second thing is, and is to bear in mind this, the disapplication of the wait-and-see principle is generally regarded as a good thing. Now, the other side, why did Parliament intervene to say, sorry, I put it wrong. The wait-and-see principle is regarded as a good thing. That's why the Parliament in this country and Parliament in Bermuda introduced a wait-and-see principle. Now, you then have to ask, did actually anybody consciously here, by putting in the word might, were they intending to do something which actually on its face appears irrational, which is to exclude the wait-and-see principle? Now, it is possible, but what we do not know, we have no reason to know why they were concerned about that. My friends say, oh, well, it must have been they were concerned about boomerang, but it's actually difficult to see why that was a specific concern where you're making a transfer to a trust. All that you can say, the only thing you can fairly say is that for certain types of situation, they decided to possibly disapply the wait-and-see rule. It's not even clear that that is actually what they've done. I mean, the mistake may be to have introduced the word might. One simply doesn't know. It's pure speculation. But what we say is you can't work from something which is cockeyed and say, well, they did something cockeyed, so I'm going to apply that cockeyed view across the board to something which they didn't apply it to. That's really my simple point on that. And The final point, I think we can then turn to. Well, I see we've really got to.
We've got 3 minutes.
We've got to 3 minutes. Well, we say the point we're dealing with is misconceived, A, because of the vesting rule, B, because of the appropriate construction of Clause 9, and the third point is the disapplication of Clause 9. And we've set out our case on that in writing. And I simply say this. This is the classic type of case. It is not suggested that deleting the word might would require any separate consideration by the trustees. The trustees intended to make the transfer. This is the classic case in which one would apply the rule, which, as we've said in our written case, has been in existence for, I think, 250 years or thereabouts. And in our submission, it would be a strong thing indeed to say today that one's going to abrogate that. And I should say that there is nothing inconsistent with in the way Mr. Hagan put it, with the fiduciary rule, because the rule is not saying you're excused from your fiduciary powers. It is looking at a situation where you have done everything that is required, but essentially there is some slip where you failed to notice that here you needed to delete the words might. You intended to do everything. You've done everything that is required, and the court simply says, well, as a matter of law, you are treated as having made that change. So, my Lord and my Lady, those are my submissions. Thank you for your patience, and I'm sorry if I've sometimes had to gabble through things, but I hope I was able to get my points across.
Mr. Howard, thank you very much.
My Lords and my Ladies, since we ended with remoteness of vesting, we thought it sensible to start with it, and then my learned friend Mrs. Talbot-Rice and Mr. Wilson can follow on the other points.
You've allocated the half hour between yourselves.
We have
equitably, I trust.
Equitably, and so I'm going to be very quick in a very equitable way. The first point that I need to deal with was in answer to a question from Lord Burrows, my Lord Burrows. He said, so I understand your submission. You are really just saying that just as the remoteness of vesting rule does not apply to charitable purpose trusts, it also by definition does not apply to a non-charitable purpose trust. Mr. Howard, it is as simple as that. And we just have to quickly look at the statute to show that it is the exact opposite of it being as simple as that. Page 1983. A trust may be created for a non-charitable purpose. And then subsection 5, which was in force. In subsection 4, probably worth going to first. The rule of law known as the rule against excessive duration, which limits the time during which the capital of a trust may remain unexpendable to the perpetuity period under the rule against perpetuities, shall not apply to a purpose trust. And then the rule against perpetuities, also known as the rule against remoteness of vesting, as modified by the Perpetuities and Accumulations Act, shall apply to a purpose trust. So the dilemma for the board is how does the disapplication of one and the retention of the other work? And it also shows why the quotation from Professor Lionel Smith, to which you were taken at page 8196, where he said, where non-charitable purpose trusts are allowed and the rule against perpetuities is retained, the rule has to be changed from a rule against duration of interests to one that simply limits the duration of the trust, that isn't an answer. The dilemma is the retention of one and the disapplication of the other. And one of the points that my learned friend did not deal with at all was my third point, which is when you have a suite of purposes and a power to select them, and you can statutorily create a trust for a purpose, the fact that property isn't allocated between each of those purposes would be a contingency for the purposes of the rule against remoteness of vesting. And just briefly, I'll just give you the reference to this. I commend to the board's review the subcommittee report of the Bermuda Law Commission before this legislation was brought in, where they specifically say that they're going to retain the rules for private trusts as against perpetuities rather than charitable ones, and that's at page 2734 to 5. Just on Compton and Kane, those two authorities were mentioned. That is not a case about excessive duration, and I remind the board that the passages from Jarman, which Mr. Justice Romer went to in that judgment, related to the rule against remoteness of vesting, not the rule against excessive duration. And that was, as my Lady Rose said, a case where you have a trust for a purpose, education, but which is really to benefit people, and that is your common law authority as to how the rule works at common law. The Kane, C-A-I-N case, for the purposes of the transcript, not K-A-I-N, is about an unincorporated association, and at page 1921, the property vests in the members of the association, so it's totally irrelevant to this case.
Could you just give us the page? Oh, C-A-I-N.
C-A-I-N.
So that's at 6808.
Yes. Yes, it is. Yes, my lady. I'm informed by others that it is. And then the third point was, well, how can you have if I'm right about remoteness of vesting, then you destroy the policy of the disapplication of the rule against excessive duration. The simple answer to that is, as my learned friend says, the rule against remoteness of vesting is about stopping interests vesting at too remote a time, and therefore about the commencement of interests, and it's got nothing to do with excessive duration. You can have a trust where all of the interests are vested, which goes on forever, and unless the beneficiaries bring it to an end under Saunders and Fortier, there is no excessive duration at all. And then on the point about the conditional gift, my learned friend did not go to the language of 4.1 or refer to the specific point I was making about the grid shares. The grid shares did not, in 2005, have to be applied to the purposes at all, ever. And therefore, whatever the rule against remoteness of vesting is that is being referred to in the statute on page 1983, it was violated in this case. And the very final point is that on the Davis and Richardson-Wallington Industries line of authorities about imputed exercise of powers, we do say in our written case that there would have been materially different considerations which the trustee would have had to have taken into account had it exercised a power of amendment, which were different from those if it was just exercising a brute power to transfer property from A to B. So even under the Gleeds exception, the principle should not be relied upon. Those are my reply submissions.
So just so I can be clear, so what you're saying is that it's not that where you've got a non-charitable purpose trust, where there are a number of purposes which the trustees can choose, then it's unlike a charity because the money given to the trust does not immediately vest in the trustee, and therefore the trust has to provide for the money to be distributed to the purposes, the choice to be made within the perpetuity.
That's exactly right. And the reason why that isn't a contingency under charities law is because all charitable objects are manifestations of some broader whole, whereas in relation to non-charitable purposes, they can be so disparate and different that the selection between them should amount to a contingency. But there is no authority on that. And you can use the statute if you want to find that property can vest in the purpose, because it says that a trust may be created for a purpose. But I say that you should apply the common law rule. It doesn't matter which one you apply. Either way, my client should succeed on this point.
But I mean, surely you can have a range of charitable purposes. I'm not quite sure that I'm following this point of distinction.
The point of distinction is that a range of charitable purposes are all manifestations of one overall concept of charity, whereas non-charitable purposes can be very, very different indeed. That's the point.
Well, forgive me for pressing on this. Charitable purposes can be very, very different indeed.
Yes, they can, but they all fall under the umbrella of the concept of charitable purpose. So providing public benefits.
So what? I'm sorry, it's probably my fault. I'm not following this point. I mean, one knows one has charitable trusts set up with very, very different purposes, and you may have a charitable trust which gives the trustees choices between different charitable purposes.
Yes, and that isn't regarded as a contingency within the rule in
what's
the
different
law.
I think Mr. Howard's point is what's different with a purpose trust which isn't charitable,
Well,
there's similarly you can choose different
the
purposes.
first point is there's a point of a legal dispute between us as to why it is that property vests immediately in a charity. I rely upon the principle that I took you to from the Wolf article, which says that it's because it's taken to vest in the members of the public for whom the property is dedicated. There isn't another way of conceptualizing that in a non-charitable purpose trust. So it's not immediately clear to me what conceptually happens in relation to the dedication of property.
You don't have to rely on that because everyone knows that the rule against perpetuities doesn't apply to charities, but what you're saying is that Bermuda has specifically said that it does apply to a non-purpose trust, even a non-charitable purpose trust.
Yes, and it says that the property can be held on trust for a purpose, and if there are a multiplicity of purposes to select between, I say, why should that not be a contingency? It may be that my Lord Sales doesn't accept my rationalisation.
Right,
for
I'm just trying to probe where you say the difference comes in.
Yes.
Anyway, thank you very much.
Thank you, my Lord.
Thank you. Mrs. Talbot-Rice.
I'm grateful, my Lord. On the first point...
Could I just point out one thing just before Mrs. Talbot-Rice commences? The Court of Appeal at paragraph 301 said that there was no matter relevant to the exercise of the power to amend, which was not also relevant to the exercise of the power contained in Clause 4, and there was no appeal against that finding.
Some short bullet points in reply on the first point, if I may. On the facts, my learned friend spent some time telling you what they were. May I commend to the board the affidavit of Susan Wang, pages 431 to 452, because not all of what my learned friend submitted is actually there. This is a summary judgment application. Our case was and is that evidence is disputed, but our position is that even if it's all accepted as true and accurate, we win. And that's the basis on which the application was made and dealt with. No findings of fact have been made despite my learned friend's submissions in various places. My learned friend's explanation of Taiwanese intestate succession wasn't quite right, so I'd be aware of that. The estate would not have been distributed in that way in any event if Y.C. Wang had made a will or if he had created more trusts before he had died. And what actually happened pursuant to a settlement agreement, so isn't a good, doesn't give you an idea of what would have happened but for that settlement agreement.
Settlement of a dispute, you mean a compromise?
I mean a compromise. On default beneficiaries, my learned friend submitted that the beneficiaries are only identified in Clause 5 to avoid a resulting trust. Got 2 points on that. Page 369, which is where one finds Clause 5, one also finds Clause 6, the heading of which is provision to avoid resulting trust. So it's Clause 6 which is there to avoid a resulting trust, not Clause 5.
I'm sorry, just to pick you up on that, it seemed to me that actually 5 and 6 really operate together. They're both directed to avoiding a resulting trust. It's just that you do it in stages. Otherwise, I can't quite see why 5 is headed ultimate trust.
Well, it's an ultimate trust, we say, because those are the trusts that the founders wished to take effect at the end of the trust period if the powers hadn't exhausted all of the funds. And I would ask your lordships and your ladyships actually to look carefully at Schedule 3, because Schedule 3 doesn't just say children and issue, it sets out trusts of quite complicated variety with stirpital successions and all sorts in there. So it's not just, oh, well, you know, if the powers aren't exercised, then let's stick in the children and issue. Some thought has been given to what should happen. So my learned friend's submission that default beneficiaries are never intended to benefit is simply not right in this case. And of course, clauses 3 and 4, the powers of the discretionary dispositive powers, there's no guarantee that either of them would have been exercised. If exercised, would have exhausted the trust fund. And of course, they could be released under Clause 12, which appears at page 371. Where my learned friend and I depart on the purpose of Clause 8 is that he says that it was there to give the trustees maximum flexibility. We say its purpose is to be derived from the purpose of the original gift, and that was to benefit the Wang family. 3 points in reply on that. Even on my learned friend's case, The original gift was to benefit YC and YT Wang's children, and your lordships and ladyship can see that from yesterday's transcript, page 85, line 23 to page 86, line 4. They give a reason for it, namely it was all about this incentivisation scheme, but whether or not that's right, it's still for the benefit of the children of YC and YT Wang. The second point is there's nothing to support the maximum flexibility construction that my learned friend puts forward, other than the fact that a power to add and exclude beneficiaries has been bestowed. So my learned friend's argument simply assumes the result he wishes to achieve, and in assuming that result, he has to ignore entirely both the fact that there are identified beneficiaries of the GRT, properly so called, in whom the beneficial interest in the trust assets actually vests, and he also has to ignore the identification of children in issue as objects of the discretionary dispositive powers. The third point is that he submitted yesterday, and this is at page 36 of the transcript, lines 2 to 8, that the settlor provides bounty, he gives it to the trustee, and it is for the trustee to consider what the settlor would have wanted him to do with that bounty. What that submission entirely overlooks is that the settlor gives the trustee bounty on terms. The original purpose of the gift in this case can be drawn from those terms, and the powers that the trustee is given are given for the purpose of promoting the purposes of the scheme, not altering them, in Mr. Justice Millett's words in Courage, page 4863, letter D. On construction, we say the context doesn't permit person to include the trustee of a trust in clause 8. That doesn't mean that you cross out the words in clause 1.6, quote, or any person in a fiduciary capacity, because the context does permit person to include that category of person elsewhere in the trust deed. And an example of that is clause 18.2, which is that the trustees not being bound to disclose documentation or information about the trust to any person. That, of course, could include a trustee. We don't say that class of person in clause 8 is irrelevant, as he also submitted. An additional class might be any foster children of any issue or any stepchildren of any issue, for example. Now, he didn't deal with our point that a declaration of trust under clause 3 in favour of a trustee of another discretionary trust would breach the rule against delegation, as set out by Mr. Justice McGarry, as he then was in Ray Hayes' settlement, page 4933E to H. And in relation to the distributions under clauses 3 and 4, he said, well, under clause 3, a distribution can be made in favour of, and under 4, to a beneficiary. So that means it doesn't have to benefit the beneficiary. We've given you X and A in relation to that, but can I add to that what Mr. Kessler says in his book, page 7687, under paragraph 11.3, in referring to trusts in favour of or for the beneficiary of benefit of beneficiaries. He says that the extra words add no meaning, and favour or benefit is a pointless use of synonyms. My learned friend's submissions on clause 9, he said that either the proviso is applicable to all transfers of trusts, which is our case, or in which case no circumvention of the proviso arises, because it always applies, or it only applies to transfer of some trusts, in which case no circumvention of the proviso applies, because it's specifically only for some trusts. Our point about the proviso applying to all transfers to other trusts doesn't arise at all if we're right that a trustee cannot be added as a beneficiary in the first place. We're right about that. A disposition to another trust can only be made if it complies with clause 9. It's only if we're wrong about that that our case on the clause 9 proviso applying to any transfer to another trust arises at all. And we say that this deed's only contemplated a transfer to another trust through clause 9, which means that the context doesn't permit a person in clause 8 to include a trustee of another trust. In relation to clause 15, we gave your lordships and your ladyship the reference to Mr. Kessler's book at paragraph 7.10. My learned friend referred you to the case of Gisborne. That's the case that Mr. Kessler cites in support of his proposition. And we're looking at Gisborne, and it's page 305 of the report at the top of the page. You'll see that the trustees had an absolute discretion in that case. They came before the court saying they were prepared to exercise it within the limits within which it was confided to them. And at the bottom of page 306, the court said in those circumstances it shouldn't direct the trustee how to exercise it in accordance with the rules which would have been applied if the fund had been under the control of the Court of Chancery. So it does absolutely support Mr. Kessler's proposition. And then finally, Lords and Milady, a trust for anyone in the world save the trustees would have been void for administrative unworkability. And can I correct paragraph 63 of our case, page 1774, which refers to certainty. It should have referred to administrative unworkability, as it does in paragraph 34 and footnote 32 on 1763. And where you get that from, my learned friend referred your lordships and your ladyship to Baden number 1 and to Manistee, but Ray Hayes' settlement was then decided after Manistee, and what Vice-Chancellor McGarry, as he then was, says from page 4934 at letter H and onwards, explains what your lordships and ladyship were discussing with my learned friend. There is also the Privy Council case in Chia Neo at page 5821, a will trust to apply the residue in such manner and to such parties as to the trustees may seem just, and that was void, and your lordships and your ladyship is not invited to overrule that case. So, that's important because my learned friend admitted today, or said, he doesn't shrink from saying that this is equivalent to a trust for anyone save the trustees. So he does collapse this trust down into a trust like that. If it was a trust like that, it would have been void, and one can assume that the settlers did not want to create an invalid trust. That there is a different test that, or the powers of appointment, discretionary powers, don't suffer from the same fate is a different point. If it was a trust for anyone in the world except for X, it would be void. Lords, my lady, unless I can assist you further, I think. Can you
just explain what has actually happened to the trust now? It transferred all the money to Grandview on the WFT trusts.
Yes.
And then what has happened? What is the situation with the trust?
So the trust was then declared, I think, terminated, and the trustee has been struck off the register of...
So where is the power to terminate it then?
Well, my lady, I think the position there is if a trust doesn't contain anything,
I see, and right, and the irrevocability of the trust doesn't prevent that from happening?
No. If the powers are exercised correctly, so that all of the funds leave the trust, then the trust is now just an empty vehicle, an empty receptacle, and in fact the trustee doesn't exist anymore.
Thank you.
Thank you very much.
My lords, my lady, my learned friend Mr. Howard started today with a, if I say, a big picture submission, saying that really what we're asking you to do is something radical that really should be left for legislation. Well, that argument, like so many of his that you've heard, are based on shaky foundations, which are that you've got to assume he's right, and that everybody who set up a trust agrees that he's right. Because what he does is he imputes an intention. He accuses us of imputing an intention to settlors. That's precisely the foundation of his case. Well, of course, a settlor never intends that the default beneficiaries are going to have any interest. They're just there to make up the numbers and secure validity of the trust. That's essentially his central thesis. What we do is we say, look at the foundational documents of the trust in order to discern the purpose. And that is a sounder foundation for that than simply plucking out of the air, as my learned friend seems to do, this idea that, well, if you set up a trust for your family and you put them in Schedule 3, you don't really ever intend for them to get anything. There is no basis for that. There is no authority to support that proposition and its imputation as the general idea of what a settlor intends when creating a trust of this nature. And so we come back to what we've said before, which is that we are simply applying principles of general application that arise in equity. And if I can just give you some references, we've referred already to the Thomas on powers extract, paragraph 10.159, which you'll find at 8222 in the bundle. Also, there is the commentary by Mr. Steinfeld, Queen's Counsel, who was, of course, counsel in Schmidt and Rosewood. Actually, I can tell you what he says at 2892. He says, surely the fundamental point is that all the powers conferred on trustees are intended to be exercised for the benefit of beneficiaries. And we say that is with the greatest respect to Mr. Steinfeld, that is a trite proposition, and it is absolutely clear, and it is one that applies across the board. And so the task for my learned friend, well, a task which we say he has failed in, is to demonstrate why Clause 8 should be treated differently and an exception to that rule. And we say that there is no authority which supports that proposition. And I want to then go on to the authorities and have a whistle-stop tour through a few points that I want to make on them. But before I do, I think it is very important to pick up on a point that my Lord Sales made to my learned friend yesterday, which is, in relation to Schmidt and Rosewood, is that the points that are at issue before the board were not argued. And again, I don't want to use my time to make very basic propositions, but given the way in which my learned friend has developed his case by reference to a number of the authorities, I think it is important to emphasise that. Because we do operate in an adversarial system where the court determines, by and large, issues based on those which are put before it by the parties through their pleadings and addressed in their arguments. And very often there are good reasons why issues are not raised by parties. And we can speculate as to why or why not the point has not been dealt with. But if it hasn't been put before the court, it is unsafe to speculate on the basis that my learned friend does. And it seems to be the sum total of the reliance on the authorities to say, well, surely someone would have raised this point if they'd thought it was a good one. Well, we say that isn't a sound basis for the development of jurisprudence. It really isn't. It isn't the way precedent works, in my submission. And I'm sure that the board is alive to that. And so I say we are not asking this board to depart from any of the authorities, because we say, properly understood, none of the authorities supports the proposition that my learned friend advances. If I can deal very briefly, I'll give some references to Hayes settlement trusts. In considering all of the cases, one has to remember the three aspects of a trustee's decision-making process: scope of the power, adequate deliberation, and proper purpose. And those are the issues that arise when a question of exercising a power arises. And Hay was a case where the trustee brought a summons to determine the validity of the power that had been conferred on it. So it was saying, do I have the power to do this? Is the scope of the power such that I can do what I want to do? And it is notable in relation to my
validity of the power. Was the issue whether it was void for some reason?
Yes, it's the question. The question is, the power that's been conferred on me, is it in terms which would render it void or valid?
Right.
And then we get into questions of certainty and administrative unworkability, which Hay and Manistee have resolved. But it's very much, in my submission, in category 1 of that three-stage test. It's am I allowed to use this power? Do I have it?
Well, it's really prior to category 1, one might say.
Yeah, maybe so. But it's certainly not a category 3 point. And the category 3 point just doesn't arise. And interestingly, at 4935 in the bundle, letters A and B, the judge makes very clear that he's not going to stray into issues that are not put before him in, I think he describes in this difficult area of law. And that I say is the right approach that's adopted throughout. Moving on to Schmidt and Rosewood, my Lord Sales made the point about the issue in this proceedings not being argued. My learned friend Mr. Howard took you to the arguments of Mr. Brownbill at 2111, but he didn't read them all out. It's important to look at subparagraph 6 and 7, which show that it was accepted that Mr. Vadim Schmidt had some rights as an object. It was just that he didn't. What was an issue was whether he had a right to get information about the trust, and that was the question that was being determined in that case. And it may well, we don't know, have suited the parties not to argue that the power was constrained in any way as a matter of purpose, because, of course, the trustee may have considered it appropriate to contend that it has wide powers, and, of course, Vadim wanted to be added. So, again, it's unsafe to infer that the point, if it were a good one, would have been raised and would have been spotted. And the factual matrix was very different from this case. For example, if one were going to get into those issues of purpose, who knows what the position would have been of the Lukoil executives who were named as beneficiaries? They may have been perfectly content and considered there to be a moral obligation to Vitaly Schmidt's 19-year-old son. So it doesn't provide any authority for my learned friend's case. Moving on to Manistee, that was another summons for determination of a question of whether a wide power conferred was valid or void for uncertainty or otherwise. And it involved two arguments. One, was the power sufficiently certain? And secondly, did it amount to an impermissible delegation? Nothing about purpose. In Manistee, the proposal was to add the widow and the mother of the set law. Now, the report doesn't say whether the widow was the mother of the minor children, but in any event, we say it was not a contentious or hostile claim, but as the interests of minors were involved, representation was provided on their behalf to argue that the power was invalid, and that's at 2398F. But perhaps most importantly, we say Manistee is consistent with both Tony Wong's case and Winston Wong's case. From the perspective of the substratum case, the addition was for family members. From Tony's analysis, the addition of the mother of the settlor and his widow may well have been capable of benefiting the minor children. Clearly, if they are relatives, the mother of the settlor clearly would have been the grandmother. One can see a case being made, we don't know, but it's for moral obligation and benefit for those minors. Very swiftly on to Re Beattie. You were taken to the relevant clause.
You better be very swift.
We did have an interruption from my learned friend that set me back.
You have less than 5 minutes.
I will use them wisely. 2367C to G, you were taken and read the first part of the clause. The thing to note in Re Beattie is that there's an express reference to memorandum of wishes and complying with the wishes that the settlor had. That is what the trustees did. We say it's a classic example of an incorporation of a foundational document and the testatrix in that case being upfront about the impact of her wishes and that they should be followed. We dealt with the Nin case previously. That is the only authority which can be said to deal with the purpose question, and it's the foundation of the Lewin paragraph that's relied on, and it's wrong, quite simply, for the reasons we've explained. The Lewin paragraph in question is 8290, and I do want to make one submission in this regard on this point, and it's a very important one in the context of the submissions you've heard today. It's being asserted by my learned friend, objects can enforce the trust. They're as good as anyone else. That is a gross oversimplification of the position. The Lewin paragraph at 33060 refers to the duty of consideration that is owed to the objects of power. So a trustee who has a power has to consider whether to exercise it. So if I write in and say, I know you've got a power to add, will you consider me? That's the extent of the duty that the trustee has. All rights of enforcement have to be viewed through that prism. It's expanded on in re manusty 2403, the duty itself. And all Schmidt is saying is that objects have certain rights of enforcement. It doesn't say how far they go, and that's recognised by Nolan at 2915, where he says which of the trustee's obligations the object may enforce is another matter. And that's very important because, as I think Professor Smith in his article makes the point, that if they go all the way to the enforcement of all the obligations in trust, you allow an object to enforce property rights of somebody else, and that isn't right. So the issue is up in the air. There is an ability for an object to ask the court to exercise its supervisory jurisdiction, but it certainly doesn't go as far as my learned friend says in terms of allowing them to enforce a trust fully, because it is a basic proposition that a trust, that a gift of property without an obligation, i.e. a trust, and simply a power, is not a trust. Because the trustee can just decide, I'm not going to exercise the power, and the property will run through that way. One final point on the point that was made in relation to the Schedule 3 beneficiaries today. It's not right to say that they can only benefit at the end of the perpetuity period. Section 24 of the Bermuda Trustee Act confers a power of advancement that can be exercised in favour of capital beneficiaries. And that is one aspect of an approach by my learned friend to relegate the interests of named, identified beneficiaries to one where they're virtually irrelevant. And that is a flaw in the Court of Appeals judgment, which refers to them as volunteers in many respects. Paragraphs 94, 108, 137 and 196. And that is the wrong way to look at things. They are the beneficiaries. They form the central part of the trust.
So you say that section 24 is in addition to clause 4 here, which
yes,
only applies to the capital B beneficiaries.
The statutory powers, it's like section 32 under the English Act. I'm sorry, there is one more authority I should have mentioned, which is SOFA. That doesn't assist you. It's a live, ongoing case. In fact, my learned friend, Mr. Wheel, and I are instructed for the defendant. It's going to trial in the summer. We had a rather bruising experience in front of my Lord Sir David Richards, where the strikeout of the claim was reversed. But it doesn't assist either, because one needs to look at the facts of these cases and deal with them in that way. So I'm grateful for the court's indulgence on that. Those, along with my written case, are our submissions and why we ask the board to recommend to Her Majesty that the appeal be allowed.
Thank you, Mr. Wilson. Now, Mr. Howard, one or two cases have been referred to in the reply submission that weren't addressed beforehand. If there's anything you want to say about them, you can put them in writing in the next 7 days. I'm not sure there will be, but if you wish to, you may do so.
Thank you.
Thank you. Well, the board is very grateful.
Sorry, I wasn't aware that there were cases that hadn't.
I thought there was a reference for the Neo case. Had that been referred to before?
The NIN, yes, it's the case that...
Yapchi Neo.
It's the Mr. Justice Cresswell decision in Cayman.
No, the 5821 about a trust being void.
Sorry.
I don't think that was referred to before. Yes. Well, it may be there's nothing, but I wish to be. I don't wish to give you an opportunity to deny you an opportunity if there's anything you wish to say about that case.
I'm great. We'll look and see if there's anything that was referred to that we haven't referred to. Then we'll.
Thank you very much.
We won't bother you otherwise.
Well, the board is very grateful to council for their efforts in presenting the cases in this very interesting appeal. And we're also grateful to those who have assisted council in the preparation of the case and in the preparation of the documents which we will have to consider. The board will take time to advise, to consider what advice they will humbly tender to Her Majesty. We will now adjourn.